The Honorable Chief Justice and Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admission to draw near and give their attention. For the court is now sitting. God save the United States and this honorable court.
Welcome to the 2009-2010 session of the AP government Moot Supreme Court. Court looks forward to hearing and deciding issues that will define the Constitution of the United States. Our first order of business is to announce the current orders. Writ of certiorari has been granted in case number 07343, Patrick Kennedy v. State of Louisiana. The petitioner merit brief in the case will be due by 3 p.m. on Friday, October 16th. Respondent must reply by 3 p.m. the following Tuesday, October 20th. If they so choose, petitioner may file a reply brief at 8 a.m. on Thursday, October 22nd. Oral arguments are scheduled for 9:25 a.m. on Friday, October 23rd. We'll now hear arguments in 07290, District of Columbia v. Anthony Heller. Petitioners, you may begin.
Thank you, Mr. Chief Justice, and if I may please the court, in 2002, Dick Anthony Heller went to the court to request a registration for a baby Eagle Uzi 9mm 22 caliber semi-automatic handgun pistol, and he was not granted this right under the Firearms Control Regulation Act of 1976 because it was defined as an assault weapon. Now, under the Omnibus Crime and Safe Streets Act of 1968, it states that Congress finds further that state and local governments will be crime and local problems must be dealt with by state and local governments if crime is proven to be a problem. And also in the Necessary and Proper Act clause, the Alaska Clause, Article 1, Section 8 of the Constitution, it grants Congress the power to make laws that shall be necessary and proper. And
so let me ask you a question here. You talked about, are we talking about the D.C. law or the congressional law? Did D.C. create the law under congressional umbrella law, or are we arguing about the D.C. law?
D.C. created the law, and the case at hand is about how constitutional law is under the congressional law.
And then what was the Congress Act talking about?
Showing the relevance of how showing how constitutional the firearms control regulation is.
I'm lost there. So the D.C. Act is constitutional because the Congress was acting?
Because of the Omnibus Act, which went on to say whatever you just said.
the Omnibus Crime Control and Safe Streets Act, which was passed in 1968, is that if crime threatens the peace, security, and general welfare of the nation and its citizens, then Congress finds further that crime is essentially a local problem that must be dealt with by state and local governments if it is to be controlled effectively. And that is, in fact, what the D.C. codes do. So, under the Omnibus Crime Control and Safe Streets Act, they are completely within jurisdiction.
So the Omnibus Act has nothing to do with guns. It doesn't mention specifically guns.
No, it does not. But it shows the relevance of how D.C. had the right to restrict firearms for the next, like, to go on to say necessary and proper law. It is necessary and proper, and under the Omnibus bill for D.C. to enforce that law.
Then, why is a ban on gun the proper way to do that?
The crime and violence in the District of Columbia was very high, and it was shown that 80% of the homicides after 2002 were as a result of handguns, which proves that handguns are unregistered handguns, and handguns are altering the peace, security, and general welfare of the nation and its citizens.
Is that 80% in D.C. or is that nationwide? So have you looked at the nationwide numbers to see what those are, or is this just a limited issue in D.C.?
I would say, considering the case, it's one of the issues with DC because we're only, the acting question of only for.
Correct. I just didn't know if you looked at nation numbers as well as support.
And then, between 75 and 76, there was an 8.3% drop in crime, and after 76, my apologies. Because in 76, this restriction limit.
You argue that the reason why this is a necessary law is because it reduces gun violence or something to that effect. But you give statistics in your argument that 54% of homicides before the law were committed by handguns, and then after the law was enacted, 80% of homicides were enacted.
Something to take into the date on that was 2002. Something to take into consideration with that is how society has progressed in the black market. Homicides now are these kids that are getting kids, but people are getting down to different places that aren't even, allotted to the government registration.
Do you have any statistics about registered handguns?
Registered, besides the.
To know whether or not how many of those crimes were committed with registered as opposed to unregistered.
Then let's look at why is it possible that the crimes have been committed or because of unregistered?
Is it possible?
Yeah, that they haven't seen significant unregistered. But then what in the Second Amendment allows us to say that guns can be regulated, can be taken off the street? I mean, would Mr. Heller a criminal?
No.
Would Mr. Heller have anything that would indicate that he would use his gun in a legal manner that you discussed?
He didn't.
So why then does he have what looks like in the Second Amendment constitutional right? Why can he restrict it?
Because with this, what I took from this case is what's in question is how constitutional the restriction is. And Mr. Heller was coming to the court saying that it was, he had an agenda, is what I found. In my research, he came to the court and the first thing that he wanted to propose was challenging DC and other municipalities among the United States to have their right to be infringed to bear arms. The next step was going to be not having a registered gun. HellerFoundation.org, all of his goals, there's 4 goals on that website. And the second one is law-abiding citizens should not have to register. That's government tracking, basically, is what he's trying to say.
But what you're arguing is that we should. Why is he wrong and you're right?
He's not tracking registration of firearms, which is the second goal. It leads to not knowing not being able to trace the gun that shot John Doe in the street, trying to come and, find the.
So all you're arguing then for us is to just rule that all of us do it. The handgun ban is unconstitutional as long as it doesn't. Is that what you're arguing?
No. Handgun ban is constitutional because in the clauses, the well-regulated militia concept. That's the well-regulated militia. The 2 clauses of the Constitution, as a respondent says, can be changed to better alter the argument. But it's always throughout the years the commas throw people off. Because of the well-regulated militia, that doesn't mean that everyone can have guns.
As far as the Second Amendment goes, a lot of debate is involved on the interpretation of it, and the wording used, and the punctuation, and there have been several different problems brought up, but there's been no real interpretation. The District of Columbia versus Heller is the first court case truly